And the record shall now show that the jury is in the courtroom. Mr. Jones,
Yes,
I
sir.
believe you are the jury foreperson.
I am.
And I'm going to ask you a couple of questions. Number one, the court has received a message from the jury that the jury has reached a verdict in this case. Is that so, sir?
Yes, sir.
Is this a unanimous verdict? That is one that is agreed upon by all members of the jury?
It is.
Do any of the jurors disagree with your foreperson's representations? No disagreement. It does appear to indeed be unanimous. If you would be so kind, pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict. And the defendant shall rise. In cause number 22-39014, the state of Texas versus Stephan Rayvon Angel, we, the jury, find the defendant guilty of the offense of murder as charged in the indictment signed by the jury foreperson. The verdict is received. It is made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time, I have accepted your verdict finding the defendant guilty of the offense of murder as indicted in this case. And that brings us to a close of phase one of this bifurcated two-part trial. We will now proceed with the punishment phase of this trial. And once again, let me repeat, you are still under the instructions that the court has given to you up to now. Let me see lawyers, please. Thank you. Break for lunch. Can all of you return back? Is 1:30 going to be enough time? It's 1:23 now. That's a little over an hour. Is that good? Okay. Thank you. And we'll wait on you if you're coming in from lunch a little tardy. That's all right. Please remember the instructions the court has given to you. We'll see you all back at 1:30. Thank you very much. Everyone else remain seated while the jury exits first. Thank you.
Okay. Here's where it all goes down.
You get this right.
It's not
Oh,
quite
okay.
on camera. I believe it's out by that door that everybody's exiting. But you get to see the judge's reaction to the situation. This is everybody's fault. Everybody sent this to me. But I did 4 streams yesterday.
Anything to be brought up by the parties at this time, state or defense? We're in recess to 1:30 on this case. David, let's get your stuff done. Thank you.
It doesn't take too long, but I let it run for a couple minutes so you can just kind of see it naturally develop.
I need Brittany Armstrong. Come on up. Yes.
That's the lowest here.
Yeah, I see. Hey, get us outside right now. Tommy, come on. We need some help here.
I'm just speculating, but I think Steven's got off the bench to go over there and chew their ass personally. That's what my guess is. Which is fun. Oh, they have it all on video. It's just not the one that was streaming. They've got it all. I think someone told these two to go on in and have a seat. There may have been implied use of a taser with that request. So the guy in the foreground, I think he's some sort of attorney or something. He's familiar with the situation. I let it run for a minute just to give you the opportunity to see him to walk over and tell them how host they are. There we go. Come here, I got something to tell you. Yeah, come here. All right, you see, the thing is, starting a fight in Steven's courtroom is a really, really bad idea. I think you're screwed. Okay, I made all that up.
Okay, we have three individuals here as the court would
Okay, they then took their lunch break and we're back, and here's how he kicks off court after lunch.
place in the record. Within the last hour, the court received a verdict from the jury in the case of Stephen Angel in a murder case, and the jury found the defendant guilty of the offense of murder as alleged in the indictment. So the court accepted the verdict and then broke for the lunch hour. And as participants and the jury and spectators were leaving the courtroom, this court saw some activity at the doorway, and I could see one or two bodies, and it was obvious that physical confrontation was going on at the doorway, inside the doorway, and at the doorway of this courtroom, as the court was still in session on this matter. I've reviewed a video because we got videos everywhere, and I see three people flailing, punching at each other at the doorway of this courtroom.
Behavior in this case is disgusting.
And breaking some of the chairs outside, but it was a free-for-all fist fight going on. Y'all three, I recognize all three of you. This is a court of justice, a courthouse of justice, of honor. This is the last thing that should ever happen in this building, because we're trying to resolve problems in a humane and dignified and educated and advanced method. We're not cavemen, although you three acted like it, like we were back in the caves again, without any rules, without any sense of respect for each other. The proceedings moved forward in due process. The jury had their job, the attorneys had their job, and then we went through the penal code, the code of criminal procedure, and the rules of evidence to get to a disposition.
The world frightens and confuses me. My primitive mind can't grasp these concepts.
Like we do in every case, using the rule of law, not fist fighting in front of the public. Can you imagine if this is what we did normally? We don't really need a building. We just meet and punch it out. We're not cavemen. We're supposed to be advanced thinkers. But not everybody thinks advanced thought. That's foolish. That was foolish. And I see assault.
Judge, I don't know if anybody has the expectation that these guys are advanced thinkers. I mean, like, I hate to burst your bubble in your mid-roll, but I mean, like, let's get real.
Now, I understand that no one wants to press charges against anybody, but let me tell you this, I'm pressing the charges. You do it at the door of my courtroom while in session, you're going to get held in contempt of court. All three of you are charged with contempt of court. Carries
John.
with it up to 60 days in jail, 180 days in jail, 6 months. 6 months.
Absolutely.
And don't think I won't set an example, because this isn't going to be the kind of activity that decent, law-abiding, advanced human thought in America is supposed to be about. And it'll be made an example out of. And we got the video, and it didn't happen exactly in my presence. So it's going to be what's called constructive contempt. It still happened over this court's authority and power at the door of its courtroom while in session, which means
my God, over lunch he sat there and rummaged through the statute and made sure that he had the appropriate authority. Like he was cranky. He didn't eat. He sat around and think, how am I going to tag these guys? Which is good, because we need that. We need to maintain order in the courts. He's absolutely correct for doing this.
I can't hold a hearing right now, but what I'm going to do is you're all arrested. You're going to go to jail, and we'll bring you back, and we'll have hearings on each of these cases, and I'll get to make the determination up to 6 months in the county jail. And don't you think I won't make an example, because this isn't the kind of behavior which you can do and then walk away from it.
Well, let me tell you how those hearings are going to go, considering the fact that he overheard the fight, then he went out and observed the aftermath, and he has video of the entire event. Let me tell you how those hearings are going to go for you. Not well.
As though nothing happened. We're supposed to set examples of behavior for all of us. And some of these cases have terrible situations. I presided over the James Byrd murder cases. I was one of the prosecutors. You don't think that was hostile? Because there were a lot of folks who felt like justice needed to be served in different ways. But we did the rule of law. The rule of law worked. Those people were prosecuted and then executed for what they did. You don't think that the experience and the sacrifices that we put in to see humanitarian ways of doing justice and the rule of law and due process works? Or is there another way? No, it worked so that the people knew that this Constitution, the flag, and the rules in the Constitution are something to be honored, that we handle our problems in a disciplined, mature, advanced method so that we are the example for the rest of the world. But
yep, you just crossed a guy who not only is a sitting judge for a long time, well respected, but his glory days consisted of prosecuting somebody into death. It was really not a good idea.
That's not the way that worked out there in that doorway. All y'all did was that acted like the kids do at school grounds before we learned and get educated, duking it out there in front of everybody. People are here to resolve their problems in an honorable, disciplined way under the rule of law. What kind of example is that set that y'all can duke it out and just flail at each other, break things, and disrupt the proceeding, disrupted my proceeding. I had to stop the proceedings that we were conducting here to finish this. But you got my attention, and you're gonna have hearings, each of you, and I'll get to make the decision, because you don't have a jury trial. It's in front of me. And you can be ultimately sentenced in jail up to 6 months. Does everybody understand that? All of you? Okay, I need everybody's names. Yours first, sir.
Charles Nicholas Jr.
All right. Spell your first name is Charles.
Yes, sir.
I was just praying someone would go sit here. I really was. We couldn't get that lucky, but I really want someone to get into the whole corporate fiction routine right now. There'd be a firing squad before the end of the day.
Your middle name, sir?
David. David
And surname, last name?
Nicholas. Nicholas.
And you, sir?
Charles Nicholas Sr.
And you, sir? Your name?
Last name Angel. First name S-T-E.
Okay, now we're in a Keenan Peele sketch. Elkhorn State.
R-O-N.
How do you pronounce that? How do you pronounce it? Steron? Steron?
That'll do.
It is. It's Aaron.
Okay, what we call this is what's called constructive contempt. That means it didn't completely happen in the court's view, but it happened where it disrupted the court's lawful duties in our hearings because it all occurred at this doorway. Turn your phone off, please. Thank you. It's called constructive or indirect contempt. And again,
Okay, so this is how this works because I'm an old dinosaur myself. Okay, this is why I can tell you he looked this crap up. At the end of the day, people think that judges and attorneys just like memorize the entire code. We don't. We learn and forget portions of the code 1,000 times. He does not have that off the top of his head. That means he didn't go back. Well, he might have eaten something, but he's sitting there rummaging through the code, making sure that he's got all of his T's crossed and his I's dotted on ringing these guys up. The question in his mind is, can I order direct contempt because they were right at the door, and is it premised on that? That's what was bothering him. I guarantee you, he looked it up. He's comfortable he can do it, and that's why he's citing the statute directly to these people who cannot understand two-syllable words. I'm just like, for me, it's fun to read through that.
this is what's called criminal contempt rather than civil contempt because you can be placed up to 6 months in the county jail. So all of you will be arrested. Each of you are going to be, there's a bond that I'm ordering.
Oh, it's definitely criminal contempt. I mean, you're committing a criminal act in the courthouse. But he was confident of that, but he wanted to make sure that he could ring him up for 6 months. He didn't want to be dishing out civil contempt. That's lame. I think you only get 60 days with that in Texas. He wanted to be able to put him away for half a year. Before we get into the underlying charge, by the way.
Of $1,000 in each case. For each case, I'm going to set this for a hearing.
This is just contempt. A prosecutor can bring a charge for assault and battery on all of them. Separate. A separate charge from contempt. The contempt is because they did it in court.
In 4 to 6 weeks. And if you're unable to hire an attorney, one will be appointed to represent you. Are all of you going to be able to hire attorneys, or are you going to need appointed attorneys? Sir, you're going to hire somebody, and you, sir, Miss
Point.
You want somebody, we're going to get you to fill something out. I need him to do an indigent form. If you're indigent or unable to hire somebody, one will be appointed immediately to help you, okay?
Y'all hold on, we're gonna take him into custody properly before he fills that out. You want to take those cuffs off.
That will be done later. Okay. I think that's, you've been given notice of.
I love the bailiff. Well, let's cuff him first before we get into all the intricacies here, Judge. You're not the one who has to deal with this. and Stevens is like, fair enough. That's a good plan. Go ahead with that.
What you're charged with assault is under section 22. A person commits an offense of assault if the person intentionally, knowingly or recklessly causes bodily injury to another, or intentionally or knowingly threatens another with imminent bodily injury, or intentionally or knowingly causes physical contact with another when the person knows or should reasonably believe that the other will regard the contact as offensive or provocative. The offense is generally for assault a Class A misdemeanor, which carries with it up to 1 year in the county jail. But the court on proceeding with contempt in a contempt proceeding, again, can sentence the offenders up to 6 months, but you have an opportunity to be heard with due process and present evidence on your behalf in to answer the proceedings. And again, criminal contempt is punishable because it concerns an act which affronts the dignity and authority of the court. And the primary purpose of criminal contempt proceeding is to vindicate the public authority. And
amen, brother.
Committing assault.
Reading the statute, it's absolutely necessary. Not enough judges enforce these things. It's fantastic. It's one of the reasons why I love Judge Stevens. It needs to be done. You cannot be having fights break out in court, or you literally do not have a court system anymore. Contempt power is absolutely essential. If you cannot maintain order in the court, then you don't have justice. Period. End of statement. That's it. Then what you've got is public brawls hosted by the government. There's no in between.
In the doorway of a courtroom, where in this courthouse, where justice is the determining goal in all of our proceedings in a dignified and non-hostile way.
Well, yeah.
Of advanced human actions and thought. That's the way we're supposed to conduct ourselves. And every case has emotional issues. We never have problems like we had.
Emotional damage.
Had just a moment ago. And that cannot be tolerated, and it will not be. It will have its punishment attached to the actions. Does everybody understand? All right, that is all. We're in recess on this. Then you're all taken into custody, and $1,000 bond.
Can I get started? No, we'll take care of it. We're going to have a story on it.
Yeah, talk to the bailiff and they'll work it out with you. Thank you. We're in recess.
I didn't watch this trial online, but everybody did that. And there was just literally the only reason I didn't do this particular case is I had so much material yesterday, which was fantastic. I love days like that. But I literally streamed 4 times, 1 on Vlog Talk and 3 on Law Talk. So I just didn't get to all the good stuff that was out there yesterday. And that's what Saturday's for. All right. Speaking of which, I got a nugget from MGT. This is MGT's fault. I have not seen it, but while I was putting it together, it looked very promising. It comes to me through Zach, of course. Zach has got 2 channels, Law Nerds Unite and Court Shorts. And yet still, everybody sends him videos to cut up for me because he is a computer nerd and he's really good at it. That's the truth of the matter.
On the record in the matter of the state of Michigan versus Thurman Hakeem McCall, counsel appearance.
Thank you, Your Honor. Jonathan Foreman, Office of the Public Defender, here with Mr. McCall, who is currently walking up to the camera. We waive his in-person appearance this morning.
Are you Mr. McCall?
Yes, Your Honor.
Okay, Mr. McCall, I have a felony complaint here that I'm going to arraign you on. The allegations are that on or about July 18, 2025, at 6099 South Martin Luther King Boulevard in the city of Lansing, Michigan, that you did make an assault or assault and battery upon a Lanisha Shante Shirley, an individual with whom you had a dating relationship, and that this was done contrary to Michigan Compiled Law 750.812. There is a third offense notice. The allegations state, take notice that the defendant was previously convicted of assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating Michigan Compiled Law 750.812 on or about April 28, 2016, in the 60th District Court, County of Muskegon, State of Michigan. And again, by violating MCL 750.812 on or about April 30th, 2024, in the 54A District Court, County of Ingham, State of Michigan. And therefore, upon conviction, will be subject to an enhanced sentence under MCL 750.815. Restitution may be ordered as this offense may have resulted in damage to another individual's personal property, a physical injury, or death to another individual. Count 1 has a maximum penalty of 5 years and or $5,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is, however, an habitual offender fourth offense notice. It states, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about March 6, 2023, he was convicted of the offense of weapons carrying concealed in violation of MCL 750.227 in the 20th Circuit Court for Ottawa County, State of Michigan, and that on or about May 15, 2023, he was convicted of the offense of controlled substance possession of methamphetamine in violation of MCL 333.74032B1 in the 14th Circuit Court for Muskegon County, State of Michigan. And that on or about March 6, 2015, he was convicted of the offense of escaping awaiting trial for felony in violation of MCL 750.1972 in the 14th Circuit Court, Muskegon County, State of Michigan. And therefore, the defendant is subject to the penalties provided by MCL 769.12 that enhances count 1 to a maximum penalty of life if the primary offense has a penalty of 5 years or more. Your primary offense does have a maximum penalty of 5 years or more. You understand the charge and the maximum penalty? Do you understand the charge and the maximum penalty, sir?
Oh, yes, ma'am. Yes, Your Honor.
You have the right to counsel. Mr. Foreman is here to represent you while you are being arraigned. But you do have the right to have an attorney represent you at all stages of the criminal prosecution and at all of your court appearances, and if you're questioned by law enforcement. And so if you can't afford to hire an attorney to represent you, you can make a request to have counsel appointed at the expense of the public. Do you understand that?
Yes, ma'am.
Okay, thank you. And so, is he requesting public defense to represent him?
Yes, Judge.
The court will enter a plea of not guilty on your behalf, but I will advise you that you do have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue all the way to a jury trial. You are being charged with a felony. You do have the right to have a preliminary examination. You have the right to have that examination within 21 days of today's date, unless you waive that timeline or the court for some reason finds good cause to go beyond the 21-day timeline to reset it further. You're currently scheduled for a probable cause conference before Judge Stacia Buchanan on August 1st at 2 p.m. You can appear via Zoom or in person for that.
Yes,
You also
ma'am.
have the right, you have the right to have that preliminary examination, and that examination is scheduled on August 8th before Judge Buchanan in person at the court at 9 a.m. Did you receive a notice to appear?
Yes, ma'am.
Thank you. Okay. You have the right at the time of your preliminary examination to require the prosecutor put forth evidence that would establish that they have sufficient probable cause that a felony was committed and sufficient probable cause to charge you with the felony. Do you understand that?
Yes, ma'am.
Okay. You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. And you have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will go all the way to a jury trial. You are presumed innocent until proven guilty, and you can maintain your innocence and take this matter all the way to trial and require the prosecutor prove beyond a reasonable doubt each element of the charges being brought against you. You have the right to maintain your silence at trial and not have silence be used against you, or you can waive your silence and testify at your trial if you like. You have the right to subpoena witnesses that will testify on your behalf, the right to see, hear, or question any of the prosecutor's witnesses. Do you have questions about those rights, sir?
No, Your Honor.
Are you currently employed?
No, Your Honor.
You're unemployed? How do you support yourself?
Because I'm standing the men's mission right now, and they helped me with my SSI because I was in a wheelchair for 5 years, and I just started walking, so I ain't able to get a regular job like everyone else right now. But they working with me in my house and everything else, Your Honor.
So you'll be looking for employment is what you're stating.
Once everything come through, they say I'm able to look for a job because SSI, they say you cannot get no job while you waiting, I think. Well, my case manager told me, so it's gonna mess that up for me. So
Okay. What address are you staying at?
what'd you say, Your Honor?
What address are you staying at?
The city rescue mission for the men's, right there across from capital city Myers. I don't know the address. You got the
It's
address?
430 North Larch, Your Honor.
Thank you.
Okay. Sorry about that.
For men's. That's too good.
Your Honor.
You're fine. Okay, let's see. What's your phone number if you have one?
517-299-3015.
Are you on probation or on parole?
No, ma'am.
Exciting and new.
Counsel, you can make your bond motion.
Thank you, Your Honor. I had the opportunity to speak with Mr. McCall. The court's aware of his prior criminal history, but he has lived in the Lansing area for the last 2 years or so. He currently doesn't have an address and would not be able to meet bond, is my understanding. It does seem, and I think it's clear to the court, that he has some medical issues, as he just expressed, and I imagine that being in the jail would exacerbate those medical issues. For those reasons, we would ask the court to consider a personal bond in this matter. Thank you.
What, acute stupidity?
You have any other court cases pending at this time?
No, ma'am.
I have a bond recommendation here from the prosecutor's office. It does indicate there's a concern for the protection of the public. It states that the defendant is either on parole, probation, or has other pending criminal matters. He says otherwise. I'm not sure why they have different information than he does. It states here the crime charge involves violence towards another person. The defendant has a history of violent behavior towards the victim and a history of threatening and or harassing behavior towards victim or witnesses, and there was an intimate partner relationship. These allegations involve a crime in front or in the presence of children, and that there are other factors, including attempts to isolate the victim to prevent the victim from reporting the crime. The people are requesting $150,000 cash surety bond and a no contact order. I will say for the record that the defendant is facing at this point up to life in prison because of the third offense notice and then the habitual offender fourth offense because of how many times he's been convicted, and then also because of the amount of violent offenses that he has on his criminal history. It's a pretty extensive criminal history. So a personal recognizance bond based on these factors would not be appropriate. There is a threat to the public safety. I don't have any information as to how or if he has, how many times or if he has missed court in the past. All I have now at this point is his criminal history, which is extensive. And then information from the prosecutor's office that he is either on parole, probation, or has another pending criminal matter. So I don't know why they would know that and he does not. I reviewed his criminal history and I don't necessarily see anything that would indicate to me that he's on probation. I do see a 2023. Oh, wait a minute. Well, I did see a 2023 conviction that he was supposed to be sentenced on, and then I see a 2024 conviction. So I'm not sure what they're referencing. I don't see anything here that tells me that he's on probation at least. Yes.
I apologize. For the record, I'm looking at anything in our internal system, and I'm seeing that his last cases were resolved in 24 with a time served sentence. So perhaps the prosecutor's office has information from outside the county that I don't have, but certainly nothing within the county that would indicate he's on probation or parole or has another pending case at this time.
Yeah, there's nothing that I have on his criminal history that would indicate to me that he has something else pending, at least not at this time. He is indigent. I think that's apparent by some information that he's provided. So I don't know that $150,000 cash surety bond is necessary to secure his return to court and to protect the public. But the court will not grant a PR bond. Bond is set in the amount of $10,000 cash surety with GPS tether.
Excuse me, Your Honor.
Mr.
Yeah.
McCall, not right now.
Okay.
While on bond, you have the following conditions. You're not to have contact directly or indirectly.
That's a reasonable bond, give or take. It was a reasonable ask from the prosecutor as well, by the way.
With the protected party, Lanisha Shante Shirley. Do you understand that?
So this a felony, not a misdemeanor?
This is definitely a felony. You're definitely facing up to life in prison right now.
Ma'am, because they said.
Mr. McCall, I'm going to advise you not to say anything further at this time.
Sorry about that. Sorry about
Your
that.
Honor, if you could please spell the name of the protected party just for our records.
I have LENASHA for Lanisha. A common spelling on that.
Thank you.
You're not to be within 2,000 feet of wherever she is. You're not to have contact directly or indirectly with her. No third-party contact. No contact via text message, Instagram, social medias of any kind. You cannot call her from the jail. The prosecutor.
That was some top-notch on-the-fly editing. I'll have you all know.
His office will check your jail calls. So you shouldn't try it. You shouldn't try to use someone else's jail PIN number to make the phone calls. That doesn't work either. Do you understand that?
Yes, ma'am.
Okay. You need to report to all of your future court dates if you're released from custody. You're also not to travel outside the state without prior approval of the court. You're not to use drugs or alcohol without a valid prescription. You're not to possess a firearm, ammunition, or weapon of any kind, and you must report to pretrial services within 48 hours of your release from Ingham County Jail. Do you understand that?
Yes, Your Honor. But I got stabbed in my face. I got stitches in my face. And I got a sprained ankle, man. I ain't no threat to nobody or the public.
Mr. McCall, I'm going to advise you to not speak any further at this time.
I
Okay. Okay. I recognize you probably have or need some medical attention about the stitches if they're not dissolvable. I don't know anything about the sprained ankle, but I'm sure you can send a kite to get that looked at. If the allegations in this complaint are true, that I don't think that either the sprained ankle or the stitches prevented you from finding your way in custody today. So I think that you'll get that treated while in custody so that we can maintain protection of the victim, the public, and make sure you get back to court timely. You're not actually eligible for a personal recognizance bond due to the nature of the charge and your prior criminal history, okay?
Ma'am, they didn't tell me about none of
Mr.
this.
McCall, I'm going to advise you not to speak any further at this time.
Because I ain't did, man. I ain't did nothing.
Mr. McCall, we'll sort that out, okay?
I cannot do that when I'm in prison. I can't do that, sir.
You're not in prison. You're not in prison.
Y'all telling me I'm facing life. I'm just something new that I ain't did.
Mr. McCall, we're going to get an attorney assigned for you. They'll be able to discuss things with you as soon as possible, okay? But for right now,
I'm not
speaking back to the
understanding
judge
this.
isn't helping your situation.
like being locked up. I'm not doing nothing wrong. Y'all. Like I gotta get my Section 8. I got custody of my child. Like just really a step back right now, and I ain't did nothing wrong. But people had made false allegations.
Mr. McCall, I'm going to advise you not to speak.
Him having custody of a child, if that is true, which I have serious doubts about, is one of the best reasons for him to be incarcerated right now. So that child has a chance to actually be around a reasonable person.
Any further at this time?
Ma'am, excuse me, Your Honor. I'm not trying to be disrespectful, nothing like that. It just
Well,
right now.
let me stop you. Let me stop you because again, I just heard your attorney at least 4 or 5 times advise you that it's not in your best interest to speak. And so I'm going to remind you of your right to remain silent because anything that you say can be used against you. Now, if you want to not listen to the attorney's advice and speak and ask a question, feel free to do so at this time.
You should ask some questions, ma'am.
That's if you do not want to listen to your attorney's advice.
Oh, no.
You can feel free to ask me whatever you or tell me whatever you want, but you've been advised by your attorney multiple times that you should not speak.
Man, okay, Your Honor. I was trying to tell you, like, I had just got hit yet last night because they said the charges might be dropped.
Mr. McCall, I'm going to advise you very strongly to not speak about the charges or the case in any way.
This guy is just his attorney for this appearance. He's doing a fantastic job. I mean, just keeps telling him to shut up, but very professional, very on top of it. But there's a limit to what you can do.
Okay. So this means I lose my Section 8 and then my custody rights of my son, right? Because I'm going to jail right now, sir.
You're not under a sentence, sir. So you need to get a bondsman and see if you can post a bond. Your attorney once assigned can review the file with Judge Buchanan next week at your probable cause conference and make a new bond motion. But at this time, bond is set at $10,000 cash surety. Okay.
I don't have that. I'm standing in the mission, man. I really don't have that. And they.
I recognize that. The people were requesting $150,000. I did not grant that because I think that is extremely high under the circumstances of your financial condition, not extremely high under the circumstances of the allegations, okay? So I did take into consideration that you are indigent. So nonetheless, I don't believe that we're getting any further advancing by going back and forth. My bond is set. You're all set.
Go follow me. Go straight, it's fine.
There you have it. Bonus clip. That was a lot of fun. The guy could not shut up. I mean, he is low functioning. There's no two ways about it. It is funny. You stand at the shelter for men's. That's all you need to know. That's all you need to know about this situation. Everything else is implied by that statement. All right. Good job, Judge Stevens. Holding up the rule of law. Thank you, MGT, for that clip. That was a lot of fun. And thank you all for coming out. I appreciate it.